Hello, hello. This is AIB Radio. We're going to talk here tonight a little bit about the foundation of the Coram Nobis and the Coram non-Juda here. Seems to be some confusion here on these documents. So we're going to sit here, we're going to open up, and we're going to explain a little bit about what these documents are, so you can have a better understanding of what this stuff is, how it's supposed to work. We need to go back in, and you need to understand several different things here on these documents. Number one, it goes back in and exposes the entire fraud of the court system. It goes back in and shows how the courts have been operating under the Foreign Sovereign Immunities Act, and how they've been given themselves immunity and have been operating in a foreign state capacity against American citizens in this country. You need to go back and read under the Federal Rules of Civil Procedure, Rule 4J. You also need to go back and read under the Federal Rules of Civil Procedure, Rule 17, of interested party, on who can bring charges against you in that courtroom. These are some of the foundations that you're going to have to go back in and understand. And you're going to have to also understand that we are exposing these judges to a lot of corruption, and we're going back in, exposing the embezzlement that the courts are creating against the people. First off, the judge is not supposed to be the one who is sitting down and setting the jurisdiction in these courts. That jurisdiction falls right back into the plaintiff, the accuser, whether it is the prosecutor, whether it is child services, whether it's IRS, whether it's the bank. No matter what the circumstances is, it is supposed to be set by the person who brought you into that courtroom. The Coram Nobis and the Coram non-Juda is strictly a defensive tool. It is for challenging the jurisdiction of these courts. It's not designed to go in and be used as if you are the plaintiff. Go in, because you don't want to go in and sit down and say, well, I'm the plaintiff here, and this court don't have jurisdiction. This is strictly for a defensive move. It's strictly for the defendant to come in and defend himself within the court system. You're also going to find out that when you start running this, the judge are going to be very intimidated with some of this stuff. They're going to want to go out, and you're going to have your paperwork either a possibility of being dismissed by the court, being frivolous, being stricken from the paperwork, being stricken from the record. Judges are going to do everything they can to get around this, because with this documentation, the judge only has two options with you. And these two options that he's dealing with, either he has to dismiss this thing in your favor, or he's going to sit here and blatantly break the law. But before he dismisses this thing, he's got to get you off subject, got to get you off point. And the Coram Nobis and the Coram non-Juda is only two things that you have to do. Two. One is stay on point. No matter what that judge tries to do to get you off, you have to stay on point. And that point is jurisdiction. Like we have discussed in other episodes, jurisdiction is supposed to be set by the accuser, because there's so many different types of jurisdictions out here, such as admiralty jurisdiction, which everybody has talked about, maritime jurisdiction, administrative jurisdiction. You have federal jurisdiction, you've got state jurisdiction, you've got county jurisdiction, you've got municipal jurisdiction, you've got religious jurisdiction, you've got criminal jurisdiction, you've got civil jurisdiction, you've got family jurisdiction. The list goes on and on and on and on. with each one of these jurisdictions is also a set of laws that's supposed to go with these jurisdictions, so you know what you're doing when you're walking into that courtroom. You can't use a bankruptcy law if you're in here in a traffic case. You can't use corporate law if you're out here on a criminal case. They can't bring in maritime law if you're out here and you're dealing with a divorce. All these different jurisdictions have to be set. All these jurisdictions have to be declared so we know what the rules are when we're walking into these courtrooms. But because they're not setting them, and we have discovered that these courts are operating under the Foreign Sovereign Immunities Act, that means the jurisdiction of these courts are operating in a foreign state capacity. Operating in a foreign state capacity means that they have no jurisdiction over the American citizens because we come under the 11th Amendment. We're not subject to a foreign state. This is what these courts have used throughout the years whenever we have brought charges against our office. They've always screamed, 11th Amendment immunity, 11th Amendment immunity. We can't be sued by a foreign state. We never realized that that foreign state that they was talking about was us when we brought charges against them. Well, this also goes in the other way. If we are a foreign state to them, then that makes them a foreign state to us. That means they cannot bring the American people in and sue the American people under law or equity. They can't bring charges against us. As we've talked about the Coram Nobis, this goes back in and explains also the different aspects of this, that under the Foreign Sovereign Immunities Act, if they're bringing us in as a corporation, then as that corporation, then they have to give us immunity under this Foreign Sovereign Immunities Act. Now, what's the foundation for the corporation? Like we have discussed here in previous episodes, the Style Manual, which was a manual that was created by the Bar Association for Congress and for the courts. That Style Manual is their grammar book. This goes in and redefines the grammar that we've been taught in school. It goes in, if they use all caps, that's what makes you a corporation. This is part of the scam that they're running on the American people. We've also discovered under the Delaware Code, under Title 8, under corporations, under Chapter 6, under 617, how do you name a corporation? Well, a corporation has to have a last name. We've also discovered the Incorporate Trust Company of the Delaware Trust, Wilmington Trust, and Corporate Trust Company of America out of Delaware that goes back in on March 10th, 1899, where the Esquires, the Bar Association, has went in before the Delaware legislation and has asked them to sit down and create a law, an act providing a general corporate law, which means they wanted the natural person or the corporation to be a natural person. They wanted the corporation to have all the same rights, all the same privileges. They want the corporation to be registered within the state in the same manner as a natural person. So this is where we come up with how they nailed us. And we're also trying to get our hands on some information prior to March 10th, 1899, where the United States Supreme Court had went back and ruled several years prior to this that a corporation is a natural person, that a corporation has to have the ability to be able to buy, to sell, to be able to function within a state as a living, breathing human being. So by setting this stage, by allowing a corporation to take the image of a person, this is how the courts are nailing it, the American citizens in this country. And this is pretty much going to be probably worldwide if you go back and check that they're also bringing you in your country as a corporation. Foundation of the Coram Nobis is that if you go back in and read Black's Law Dictionary, the Coram Nobis goes back and explains to the court that, excuse me, there's been an error made. Someone failed to disclose. Somebody withheld information. Now, whether it was done deliberately, whether it was done intentionally, or whether it was done through intimidation and through threat that this information was withheld, goes back in and tells the court that someone failed to disclose information in this hearing that could have set you free, that could have changed the course of this trial. This is what the Coram Nobis is. Now, they're going to go back and tell you, some people coming in, well, they repealed this and put it under Rule 4, under Federal Rules of Civil Procedure, Rule 60. Thing is, Coram Nobis still shows up in Black's Law Dictionary today. It still goes back in. It still has the same purpose and the same meaning. An error has been made. Someone failed to disclose. You're giving this court the opportunity to sit down and correct the record. Now, what we've been dealing with and have found out is some of these courts are dismissing immediately. Some of the judges are challenging the people. People, the foundation of the Coram Nobis and the foundation of the Foreign Sovereign Immunities Act goes back in to what we've discussed back in 1933 under 49 Statute 3097, under Treaty Series 8881, under the Conventions and Duties of the States on December 26, 1933. Congress went in and relinquished the state statutes and turned everything over into international law. On December 9, 1945, under the International Organization Immunities Act, Congress went in and relinquished every single public office over to the UN, bar none. We found this and backed it up with the International Reorganization Rescind Act that a judge filed paperwork into the United States Supreme Court declaring what Congress did in 1945 was unconstitutional. It was not valid because Congress never once brought it up before the people for the people to sit here and agree to this. The Supreme Court on October 5, 2005 declined to hear this case. The International Reorganization Rescind Act was never rescinded. It's still intact today. The judge went back and made all the issues to prove that Congress did relinquish all these public offices over. Under Title 8 of the United States Code 1481, it goes back and explains that whenever you took an oath of office, you had to relinquish your citizenship to this country. Under Title 22 of the United States Code, under Chapter 11, under foreign agents, this is what happens to you whenever you sit here and relinquish. You become a foreign agent. Under Title 22 CFR 92.12 to 92.32, these are the oaths of office. And this thing falls under the foreign relationship, falls back under international law for the oath of office. These are the foundations of what we're dealing with. This is the foundations that we're never supposed to found out about and never dealt with. So this is why when we're walking into these courtrooms and we're found this kind of paperwork, it is now intimidating the courts because now we're exposing the fraud. We're now exposing the corruption and the misuse of what they're doing to the people. Now, some of these cases we've had people report where the judges have brought in extra security guards to stand behind the people. From what we have discovered, this is where you sit down and make a very simple statement and put it on the record, on the court. Is it your intentions by bringing in these extra armed guards into this courtroom that you are trying to threaten me and intimidate me, and that you have trying to cause me to have fear for my life? That by me bringing forth the truth into this courtroom to defend myself properly, you're now intimidating me and you're threatening to kill me in this courtroom by having these armed guards that all you have to do is say, shoot this person. You're now intimidating me and you're threatening to kill me in this courtroom by having these armed guards, that all you have to do is say, shoot this person down, and they're going to shoot me down in this courtroom because I dare bring the truth in? By making this issue and having it put on the record, the judge has just now been put on notice. We, the people, should not have to go to this extreme in order to defend ourselves, but they have pushed this to that point. We have people that are sitting back and complaining. The moment we file the paperwork in, a judge dismisses the paperwork. Don't worry about it. He can't dismiss it because of what we brought up here just a few minutes ago of the 1933 document, the 1945 document, the Title 8 of the United States Code, the Title 22 of the United States Code. This judge has to get you off point. This judge has to sit here and try to get you to panic, to get you to back down. This is why with this thing of the Coram Nobis and the Coram non judice, you only have two major things to do in that courtroom. That's it, two. One, stay on point. No matter what that judge does to you, you stay on point. No matter what he says, you stay on point. And that point is jurisdiction. Now, this judge has got to sit down and tell you, well, I was appointed by the Supreme Court of this state, and that gives me jurisdiction. It's no, sir, it does not give you jurisdiction. What the Supreme Court did was allow you to be able to sit on this bench through the court system by agreeing that you could be a judge. That doesn't give you jurisdiction. I'll go back and tell you, well, the people elected me. That gives me jurisdiction. No, sir, being elected only gives you a job. And seeing how you made the issue that the people elected you, then what you're telling me is that I can fire you right here, right now, today. You're fired. Because if you're going to make the issue that you were elected by me, then I can fire you. And you're fired. Get off the bench. So don't tell me that being elected gives you jurisdiction. It tells me that you're an employee of mine and I can fire you. If they bring up the issue, well, do you have a driver's license? Do you vote? Do you have marriage license? This, again, does not give you jurisdiction, sir. All this does is sit down and allow me, if I have a driver's license, gives me an address if something happens to me that someone can report to my family. The fact that I have a voter registration card does not give you jurisdiction. It allows me to put people like you in office or take people like you out of office. So don't sit here and fall into the traps and intimidation of these people when they start handing all these excuses. Because number one, it isn't up to the judge to set the jurisdiction. It's up to the accuser. Because if you go back in and start reading the complaint form, whenever you are the plaintiff, it asks you, what jurisdiction are you going to run this thing into? What's the foundation? What is your argument? You have to set the jurisdiction. That now means the accuser has to set the jurisdiction, not the judge. But this is where we've been making our mistakes. We've been allowing this judge way too much power, and this is what the Bar Association has been doing, allowing him to make all these determinations. It has never been by the attorney bringing the charges, because the attorney can't bring the charges because it's hearsay. That's why they can't set jurisdiction, because it's hearsay. This is why the courts are running away with this. This is why we've got to stand fast on what we're doing. That's why there's only two things that you have to do in this courtroom. Stay on point and stay on jurisdiction, and don't let them get you off jurisdiction. Now, this judge may sit here and say, well, let's get by this here a little bit. We've got some other issues. He says, no, sir, until jurisdiction is set by the accuser, you cannot move any farther. This falls back under the Code of Civil Procedure under Chapter 5, under Rule 418.10. You have personal jurisdiction. You have personal persona in that courtroom. Until the proper venue and jurisdiction is set, that court can't move. And now that we know that they're operating under foreign sovereign immunity, that court cannot proceed under foreign sovereign immunity. And they will never admit this. People are panicking because judges aren't following the rules. They're going to try to sit down and sidestep this every which way they can. That's why you have to stand fast, stay calm, and argue this. Like I said, the judges are going to do one of two things here. He's either going to dismiss this or he's blatantly going to break the law. There's only two choices he has. Now, we have developed several different things for paperwork. What we're coming up with. One of the issues that we are dealing with is the allocation of jurisdiction. And this is where, in documents of where the other side has to set jurisdiction. It's a requirement. They have to set it. They never do. And this is the foundation. This is what your objection to. I object. The other side has never sit down and declared jurisdiction. Stay on point. They've got 10 days to sit down to do this issue. And don't allow them to get off of it. Don't allow them to sidestep this thing. That's one of the first documents that you want to put in if you're going in for the first time. You're also going to file in the Coram Nobis. Like I said, that Coram Nobis goes in and explains that there's been an error made. With this Coram Nobis, you're going to file in also the following documents. You're going to file in the Coram Nobis Terrorist Act with your Coram Nobis. What this document does, it goes in and it makes the issue that it has come to my attention that all federal, congressional, and state legislative enactments, rules, regulations, or anything created by private corporations or associations, agencies, instrumentals, or entities that are defined under the Judiciary and Judicial Procedure of Title 28, Section 3002, is being deemed by many administrators in this field as anti-government patriot laws. If anything that we have filed in has been declared patriot laws, they have deemed us to be militia, constitutionalists. They have deemed us to be KKK, neo-Nazis. Ladies and gentlemen, we aren't the ones that created all these codes, rules, regulations. All this stuff was either created by our elected officials, Congress, on the state side or the federal side, or it has been created by corporations that Congress made privately to go back in and create the rules, regulations, and guidelines. This is what they are deeming to be anti-government patriot law. So we're going to shove it right back on them. But we're also going to go back and make the issue under the H.R. 1955, which is the Homegrown Terrorist Act, and H.R. 3162, which is the Patriot Act, under Section 800. Section 800 goes into domestic terrorism. And under domestic terrorism, it sits here and goes into quite a bit of detail and quite lengthy of what is domestic terrorism. That by that judge or administrative officer, rather, by him bringing in armed guards into that courtroom, he has just now committed an act of terrorism against an American citizen. He has now made an aggressive move against you to intimidate you, to coerce you, to threaten you, to blackmail you, to intimidate you. If you don't agree with this man sitting on the bench, he's going to order these people to shoot you down in that courtroom. And that's exactly the mentality you need to run with when you're dealing with these people, because that's exactly what they're doing. The other thing that we have developed, you're going to file in with this, is also the non-slave owner. This goes back into September of 1850. we have discovered on September 18th, 1850, that this law was repealed. This goes back in for slave ownership. This is where the registration stuff comes in at. You registering your car, putting your deed up for your home, voter registrations, birth certificates, all this comes out of the Slave Act that was repealed in 1850. What they're doing, they're bringing you in as a slave owner. This is where that straw man deal comes in. This is your slave. You have to go back in and make the issue that I'm not a slave owner. These are the documents that you're going to put in. So you're going to put in the allocution of jurisdiction for your first hearing, that the accuser had never made the issue of what jurisdiction. The Coram Nobis you're going to put in. You're going to put in the Coram Nobis Terrorist Act and the Coram Nobis non-slave owner. And we have a entry of judgment that we could file with this in order to have the judge dismiss this because the accuser has failed to state jurisdiction on your case. Now, this Coram Nobis can be put in also if you've already had your hearing, you've already been convicted. Go back in and file this back in along with the Terrorist Act, along with non-slave owner, along with the entry of judgment to go back in and have the record corrected. The Coram non-juda, if these first documents fail, the Coram non-juda is going back in and now point blank telling the court, I put the Coram Nobis in to tell you that an error was made. You refuse to acknowledge this. Now the Coram non-juda, now I'm telling you, you're not a judge. You have no authority and you have no jurisdiction and your order is void. This falls back under Rule 60 of the Federal Rules of Civil Procedure. Now you're point blank telling the judge they don't have. You gave him the opportunity to go back in and correct the record. He had every chance to sit down and do his job right, and he didn't do it. Now, with the Coram non-juda, we've got several documents for it. You have the Coram non-juda objection. This is where you start filing this in, and the objection goes into congressional records. You're now telling the court why they don't have that jurisdiction, because you're going back and explaining to them in 1933, under this 49 statute, under 3097, under Treaty Series 881, under Conventions and Duties of the State, that Congress relinquished all state statutes to put everything under international law. You point blank telling them, these are congressional records. This is what Congress did. This is why you don't have jurisdiction. This is why you don't have subject matter. That's why you don't have venue. That's why you're not a judge. That's why you don't have the authority, because Congress took it off of you. Also falls back under the International Organization Immunities Act of December 9th, 1945. You put this in also as evidence. Put it in as exhibits or evidence, however you want to call it. Now you're going back and telling the court, in 1945, Congress relinquished your office and made this office under UN. You are no longer an American citizen. You now are a UN employee. You're also going to put in that International Reorganization Rescind Act, where the judge sat down and filed paperwork in and shows that the Rescind Act was never rescinded. The Supreme Court declined to hear this case, but this goes back in and explains where this judge has blatantly, point blank showed where Congress violated their constitutional position by relinquishing every single public office in all these states over to the UN for their total jurisdiction, for their total control. We're also going to file in with this document, Title 8, 1481, where they gave up their nationality. They gave up their citizenship the moment they took that oath of office. You're also going to go ahead and put in that Title 22, that CFR, under foreign agent. The accusers are now going to have to come back in and rebuttal this. they're going to have to come back in and make the issue, and they're going to have to prove that Congress never did any of this, and these statutes don't exist.